guests with me, Sindhu and Rajat, who are joining us from New York and London. And we're just going to start off in a few minutes. Just going to wait for all our attendees to join in. So hang around, 2 more minutes and we'll get started. For those who are joining us on LinkedIn and YouTube, welcome. We're just going to get started in a few minutes. Excellent. I think we have a sizable number, and I see a lot of you have joined on LinkedIn. Please, feel free to ask questions at any time using the Q&A tab at the bottom of the screen, or if you're on LinkedIn, you can add from your comments tab, or on YouTube as well, and we'll make sure we'll start to get the panel started. Great. Welcome to Sindhu and Rajat. Thank you so much for doing this. This is an absolutely fabulous conversation to have in 2020. And what I want to do is just set a little bit of context and background, and then we'll dive back in. All of you have read their wonderful biographies, so I won't waste the next 10 hours trying to describe each and every one of them to you. They're amazing, they're experts in their field, and I'm sure the content will reflect that. So why litigation finance? What are the issues on it? Why is this such an important topic? I think one of the things that has happened across the world is that more and more, as the speed of business has started, more cross-border transactions have started, more globalization has started. Consequently, the number of lawsuits have increased across the world. Now, obviously, we have multiple standardized legal systems. We have civil law, we have common law, and we have different states. In the Middle East, for example, we still have Gulf law or some version of Sharia law, and different laws have started putting things together, particularly when it comes to cross-border transactions, and it really increasing costs. Now, just to quote some averages that I've come across anecdotally, litigations in places like the United States, UK, and particularly the common law countries usually don't have a cap on the amount of lawyers' fees that get paid, and even a very reasonable straight-up case often can cost tens of thousands of dollars just to start, and often just to litigate that it goes on to millions and millions of dollars. Now, obviously, there are a lot of companies, corporations, and individuals who use the threat of the cost of litigation as a big lever in their negotiations. Guess what? You aren't going to sue us because the cost of litigating this matter is so large that it'll send you bankrupt, and therefore we feel as a large corporation we can get away with this. And there's probably like 2-3 dozen movies which have been made, and lots of television shows all across the past 2 or 3 decades on that individual underdog against corporations. But I also want to make it very clear that this applies for B2B disputes as well. The second thing, I think the framework as third-party funding or litigation finance has come in is also, one, there's a lot of chasing of yield that is happening. And COVID-19 particularly, we are seeing interest rates and pension fund returns start to hit 2-3%. And apart from the crazy stock market options that keep going up, there is a huge amount of capital that is chasing a lot of very small opportunities. In that sense, litigation is like any entrepreneurial bet or venture. There are well-defined risk and factors and variables that a person has to take into place. Sindhu and I were just having a discussion before we started on some of the very esoteric ones, ranging from, which judge your case is in front of, who's the lawyer arguing, what is the matter on record, the defensibility of your case, what is the risk to reward ratio in terms of the cost of doing the case versus the settlement that you're going to get, and so on and so forth. But all these risks are pretty close to the factorization risks you would see in any other investment for a finance company. And that includes ranging from a project loan to even financing speculative explorations or bets. So as the world of litigation finance is slowly coming up, and we'll hopefully look at some examples today of how that is done, it's also it's raised a couple of I would say value issues or moral issues. And honestly, it depends which jurisdiction you're on. In certain countries, such as the United States, where there are massive judgments that can be got, ranging in the millions to the 100 millions to the billions of dollars, the ability to apply damages one over the other is very different from some of the European courts or even the Asian courts, which will give you a more narrow judgment that just might make you whole for whatever losses you can prove or for the contract that you were trying to litigate out, but they're not going to add jury-based punitive damages. And so the risk to reward ratios of those changes, but it's also the values of it. And, there are various terms used here. In some places, I've seen people call this that this is mercenary financing. You're just encouraging a bunch of trolls to go after people, companies which are just trying to do a good, a great product or a service. Everyone makes mistakes, and now you're funding people to go after these companies in hopes for them to give you either a small or a large settlement on this. I think that's one thing as well. It's the encouragement of trolling, particularly around intellectual property, where you have people who somehow manage to get random patents in, and now they're getting financed to go after a very large pool of companies who they claim are trying to infringe on that. But then there are also a lot of people who talk about, very simple things. As we said, it's underdog finance. There's a very big case that is to be fought, something that is worth litigating. But at the end of the day, either an individual or small company doesn't have the financial interest to do this. Other people also say that, look, engaging in litigation finance is a big checkbox on the seriousness of your case, the viability of your case. If a third party is willing to fund this, clearly within the court and outside the court, there might be some credibility to be gained here. So these things aren't simple. And that's why I'm very excited to have two incredible perspectives on this. And so I'm going to get completely started on this starting off at Sindhu. I'm just going to, big question. Can you just give us a broad base? What is TPF? And, how is it different from other traditional forms of financing? For example, taking a bank loan or asking an intercorporate loan from a friend.
Sure. Thanks, Aditya. I mean, so what is TPF? I think when we in this virtual room are talking about TPF or litigation finance, what we're talking about is an arrangement where a professional litigation finance company provides funding to a litigant to bring and run a case, and in return shares in the results or proceeds of that case. The case can be anything. It can be an arbitration case, it can be a litigation case, whatever. But litigation finance, one of its main characteristics, I suppose, is that it's non-recourse, which means that if the litigant is successful with the case, the funder gets a portion of the litigant's winnings, whatever that might be. But if the case is unsuccessful, the funder gets nothing. From that, you can probably work out how TPF is different from taking out a bank loan to bring a case. With a bank loan, you've got to pay the bank back with interest, whether or not your case succeeds. Whereas TPF is non-recourse, so the risk of loss is with the funder, not with the claimant. And if it all goes wrong, you don't have to pay the funder anything. Now, both have their pros and cons, obviously. Taking a loan from a bank tends to be cheaper than litigation finance generally, but I think litigation finance is a much better risk proposition. Also, and I mean this depends a little on the jurisdiction and the bank involved, but typically banks are likely to ask you for some sort of additional security or collateral as well for giving you a loan. They're not litigation experts, and they don't like valuing a litigation. Whereas with litigation finance, you should not need any additional security. The litigation proceeds are enough.
I think that's fundamentally a very important difference, right? It's almost like a success fee. So it's not sort of finance in the traditional sort of way where we are saying that, okay, please give us some collateral, please make sure whether you win or lose doesn't matter, profit or loss doesn't matter, you're still on the hook, right? In this case, you're able to directly connect that if you win, we get this money back. If you don't, and by the way, lawyers have done that for a while, right? They've been the original guys who sort of self-finance this stuff.
Absolutely. I mean, lawyers have been financing litigation, if we can call it that for multiple jurisdictions, and you can do it in a number of ways. You mentioned the success fee, so you get a top up on your fees if the case is successful, or as is very, very common in jurisdictions like the US, you can put some of your fees at risk, so you don't charge the client at all, but if they win, then you get a percentage of it. TPF tends to be quite different because as funders, we don't get involved in the running of the case. So the funding is separate from the legal representation. The claimant and the lawyer sort of retain control in the running of the case. And just one thing sort of worth bearing in mind is, especially in India, because that is our primary audience today, lawyers are not allowed to participate in the funding of a litigation. So that avenue to get funding is basically not available in India.
So I'm going to propose that to you, right? What Sindhu is saying, that this is not an avenue that lawyers in India can take and be a conflicted of interest participant in winning. They're supposed to be, from what I remember, the lectures that I've gotten from lawyers, officers of the court, and as officers of the court, they're not supposed to, dirty themselves with these sort of, secondary matters. But just sort of a curiosity: is this legal? Is third-party finance legal in India? Do you know if it is? And what about some of the other popular jurisdictions where we have a lot of Indian court cases fought out? US, UK, Singapore. These tend to be where the maximum of cross-border large issues and small issues tend to crop up.
I think I will jump in there. So I think, as Sindhu just said, it's really interesting that over the course of time, over the last few years, the world has evolved, I would say the sophisticated parties have evolved in terms of the financing arrangement. And unfortunately, I think the governments and legislatures still have a lot to catch up to respond to this. And I think India is probably one of those jurisdictions which is very behind. The short answer is of course legal. And I think, but if you really look at whether this question of legality in India really presents itself, that question really doesn't present in a lot of cases. So when you have a lot of companies or individuals coming from India who seek funding, most of the time you would see that those disputes, I'm just talking about arbitration, are either based in Singapore or they're based in London. And in those cases, of course, for example, in Singapore, third-party funding was not legal till 2017. And now there was a law passed, and now third-party funding is legal. And a lot of Indian clients, they're very smart, sophisticated businessmen. And most of the time when they enter into a joint venture or do their restructuring, there's always an entity that's either based in Mauritius or a BVI entity or in Europe. So that question doesn't really present itself. But I think if anyone is concerned about those, how dated the Indian rules of on third-party funding are, it doesn't really present a problem itself, because most of the time the dispute is international. Second, most of the time when you seek funding, you typically involve international law firm, because it also it also helps their client. And also, I think the funders take a lot of comfort with the fact that there's a well-known international law firm that's present in the case and is litigating the case. So most of the time when you enter into a funding arrangement, most of the time it's just not based in India. So I think I know that question comes in people's mind, but there are many ways to work this out. And of course, there has been no decision, as far as I'm aware, by the Indian Supreme Court. In the US, it's of course legal. It's done, in full swing. And in fact, unlike Indian law firms, US law firms can take a matter for 100% contingency. So a client pays nothing, which of course means that there's a huge success fee there. But I think in US, Singapore, London, India, there has been no issues. There are a lot more sophisticated, I would say, granular issues that come out of third-party funding, which we will talk later. But as far as a starting matter, whether can I do it or not do it, I think there's no problem.
So this, I think, so my clear takeaway from Rajat is where there is a will, there's a way, right? There isn't a explicit law saying you can't, and clearly the most expensive legal cases that come out of India, usually when you have an Indian party who is either part of or is suing or is defending against a broader international lawsuit, and then the cross jurisdiction rules make this happen. But I think that Rajat brings out a more fundamental question. Who is this for? I mean, who's sort of the ideal candidates for litigation finance? Because historically there's always this notion that this is for people who can't afford it. They are going bankrupt, they have a good case. Okay, we have zero cash, no reserves. How do we fight this? Okay, find a litigation loan shark who can come in and at least get this up and running. Who are these people who are looking, and who's an ideal candidate, who may not be the most ideal candidate?
Is that for Sindhu or it's for me?
Oh, it's for Sindhu. She absolutely walked in on this one when she in her opening remarks.
I think the short answer is it's not just for companies that are in financial trouble. I mean, of course, I think if you don't have the cash, if you just don't have the cash to bring a case, TPF is a necessity. But even if you're a well-funded company, I think there are a number of reasons you should consider deploying it. I mentioned risk mitigation previously because TPF is non-recourse, which means the financial risk associated with the litigation is with the funder, not with the company. And I think that by itself is a reason every company, well-funded or not, should at least consider deploying TPF. Because I mean, I think we'll all agree litigation is inherently quite unpredictable and risky, however good, your claim is. There's always a risk that things can go wrong. Your witnesses may not perform on the day. A judge or an arbitrator takes an unexpected view on a legal point. So just from a risk mitigation perspective, I think it's worth considering. And then there's also the accounting perspective, or the benefit that's often talked about. Generally speaking, right, when you bring a litigation and when you have a claim, you can't recognize the value of that claim in your company's accounts until you actually recover those proceeds. At the same time, when you're self-funding a case, and the running costs of litigation, you're paying your lawyer's fees monthly, or the expert's fee, or the court fees, those do have to be recorded in more or less real time as operating costs in your P&L. So what that means is that can kind of skew the way your earnings look over the lifetime of a litigation, which, as we know, can take several years. Now, when you bring a funder in, one of the advantages is that the funder directly pays those costs of the litigation. So there's no hit to your P&L during the lifetime of the litigation. This can be really helpful, I think, particularly if you're a earnings, EBITDA kind of a focused company. And then I suppose there are some of the softer benefits of having a funder involved, which you actually alluded to in your opening remarks. It can be a real show of strength to the other side as well as to the court, that not just you, but an external party who tends to be an experienced litigator believes in the merits of the case enough to put money in it. It can also just be helpful to have another party, another pair of eyes, another experienced litigator involved and giving inputs while running the case. I mean, Rajat may or may not agree with that, but that tends to be our experience. So I think the short answer is, even if you're well-funded, you should consider using it, just like any other strategic finance.
I mean, if I can just add one more thing there, I think it's really...
Actually, please add a lot of things there, and including what Sindhu says, are there this entire thing about, it's a show of strength. I mean, is that true? Please go ahead.
I think what I just want to add is, I think the question you asked, like what type of claimant or who is this for, I think you just have to first take a very, like a 30,000 feet view, like what type of disputes do you see in today's world? You have, two private parties in a litigation or a commercial arbitration, and you also have a private party that's going after a sovereign state, which we call investment treaty arbitration. And even if you're someone who says, well, I have enough money in my account to fight this off, you should know when you fight a sovereign state is presumed to be never go bankrupt. They have, a lot of cash flows. You're going after a sovereign state, and they can make arbitration really expensive. So I think when you are a claimant or you are thinking about bringing a case against a sovereign state, if you have an investment in Africa, I know there are a lot of Indian companies and investments in Latin America or Africa, and let's say all of your property in a state was destroyed or taken away, and you want to bring a claim, you're like, well, I still have like $40 million in cash flow, but guess what? Like, if you really want to know average cost, sometimes arbitrations against sovereign states can, just from legal fee perspective, can be $8 to $10 million. It's very litigious. It goes on for 4 years, 3 years. It's a different story when it's a commercial arbitration, because both sides have incentive. At some point, one of you is going to break down, or both of you are going to break down, because it just doesn't make sense. And also, it's public. How much dirt are you going to throw at each other public for it's the news reports, but arbitrations is all confidential. So I think when you really look at thinking about third-party funding and who is it for, I think no matter how deep your pocket is, I think at some point you have to really consider, is it really worth it? Should I not think about third-party funding? And I think it's not just for a specific claimant. I think every claimant should think about it, because I think given how litigious things get today, I think it's very helpful. And I think on the point about is this something that's really helpful, a show of strength? I think it's a tricky question, because I think for so far third-party funding, and I think Sindhu can talk about it more today, has always been viewed as a taboo, like OMG, like we should not tell people that we have third-party funding. But I think a lot of times tribunal actually view it very favorably. I don't know about the judges, because sometimes judges don't even understand what third-party funding is. I think tribunals view it as a show of strength, because they think that someone who must have funded to bring this arbitration forward must have done a lot of due diligence, and we will talk about it today with Sindhu. But I don't want to keep talking more on this, but I just wanted to jump in and say, I think you have to take a really high level view on this and see who are you up against, what's your cash flow, is it really worth it, and really go out in the market and ask around how much would it cost on average to litigate this involving international law firms if you want to, and is it worth doing this right now?
One of the interesting things, we have a lot of questions coming in, and I don't want to ignore some of the audience questions, so I'll ask a few of them in first. I think one goes to something that Sindhu had said at the very beginning, that the funders don't interfere with the case. And I think that's something that a lot of people seem to be commenting on, that they're surprised that, if they are funding and they see the case is not being handled well, is it really laissez-faire? They just say, whatever, we believe in the lawyers, or do they actually, step in at some point and say, hey, we've spent a few $100,000 or $1 million plus on this. Yeah, you guys are bungling the case, do it this way. First with Sindhu and then with Rajat, is it really that hands-off?
So it depends. It depends, I think, on the jurisdiction and the structure that's adopted. But in general, in most common law jurisdictions, it's rules against champity and maintenance mean that third-party funders ought to be extremely careful about not taking over the control or running of the case. It's for the lawyers to do. And at the end of the day, I think we're sort of really there to fund it. It's not part of the business to take over the running of the case. That said, I think most funding agreements will of course have certain provisions in there to make sure that the funder can protect its investment. And if things are going badly, for example, perhaps there are actions being taken, or the budget is not being adhered to, then there will be recourse within the funding agreement. But will the funder step into the lawyer's shoes and sort of take over the running of the case? No, would be my short answer.
And I think in my experience, I can tell you, I've been doing this for a while. I have never ever seen a funder jump in and say, tell us why you're doing this, show us your drafts or anything. It's once you do third-party funding, you sign the deal, it's done. There are certain milestones, that's it, but there's never been any interference from any funder. And you will be like, okay, this is really counterintuitive. If I put in $10 million of my investment into your litigation, I need to know how you run this, because you know what? I think I have smart lawyers than you are. But I think that kind of understanding comes from a basic, I would say, lack of appreciation, how much work is put in before a funding agreement is signed. There is so much work put in by a funder, by a law firm, to due diligence the case. There's a due diligence of the lawyers, and and the funder then, once the law firm does its own diligence, the funder goes on hire a separate firm to do due diligence of the work that law firm has already done. And once you have the comfort level, I think as an investor, you just come to a point that, okay, I trust this claim. I think this is really worth it. I know my risk, and based on that, I'm going to invest in it. So I think funders, I think, get the comfort from that and don't really try to handhold lawyers' hands. And frankly, lawyers would not like that either. And I think one of the ways, which I'm sure Sindhu will touch base today, is to further reduce the risk is by, say, do a portfolio funding where a funder says, okay, I'm obviously concerned and there's a risk in funding just one claim, but I know you have 6 other cases too. How about we call it a portfolio of funding? So basically one case collateralizes risk against other cases. So you pool in your money, and even if you stand to lose on one case, you basically get, upside from the second case. So, but coming back to your point, I think I have never seen it. I think if it's done, it's very risky, but because of the privilege issues. And I think as of now, I have not seen a funder coming in and saying that I need to be really involved in this litigation.
I think that makes a lot of sense. So if it happens, it's probably the rarest of rare. Just as you don't see most in angel or venture cap people coming in and just taking over the companies randomly. If it fails, it fails. Although there is precedent when it's a huge amount of money involved, that you have sort of the financiers come in and try to take over the assets. But I think in this case, it seems to be sort of a professional excellence. If you have funded that case, you've done the due diligence. Something has had to go very wrong in that entire process, that you have to actually come in and intervene. And presumably, and as you both pointed out, it's not just the due diligence on the case or the or the client, it's on the lawyer, right? And if you fundamentally trust that lawyer and they're really good and they're going to do it, how much better can your lawyer be, right? And at some point you have to say, okay, we use the same system where we hired our current lawyer to hire those to do the due diligence on those. And I think those are really getting the funding. I have a question on Zoom from Mr. Bala, and again, and Mr. Spuda, I'm going to take your question. I'm going to expand it out a little bit more. And one of the factors we haven't discussed is about court delays. Now, certain jurisdictions, India in particular, but also we've seen this abroad, cases just keep going on and on and on and on. And obviously, people who are in the litigation finance business, they are looking at a term by which they get their money back. How does court delays and all play into those calculations? Or that's just one more factor that is well known?
I think it's just one of the many factors you look at when you're evaluating a case. I mean, as a funder, we're always looking at not just what are the legal merits of the case and is it going to succeed or not, but also these economic merits of the case, if I can call it that. How much are we being asked to invest? How long is it going to take for us to make any recoveries? What the recoveries are and what the budget are. So the time period is obviously an integral element in working out your own IRR. And in that sense, it's just one of many factors you're going to factor in to either say yes or no, you're going to fund the case or not, and equally, it could also impact the pricing.
Fair enough. And so anyway, so it's going to be one factor in. I mean, if you're in a court system that the funder knows is going to be delayed, they're going to adjust that risk in terms of their return. They expect a 5-year return versus a 2-year return. Obviously, that's going to change how they view, how quickly this thing is going to happen or it's going to get settled. A couple of questions that have sort of come up, in our conversations. We are talking about funding, right? And one of the biggest issues which I see in funding in any industry is really figuring out structures, right? And we've had at CII, we've had a number of workshops on how to do cross-border funding, cross-border structuring, M&A, and all of that. But then also even domestically, and when we think about corporates, we think about everything from classes of shares, debt instruments, all of that. But what are the tools that do you see for third-party funding? What are these structures? What do they actually look like?
Sure. I mean, there are quite a few structures, really. It's very broad. So far we've spoken about, I suppose the simplest form of structure, a single case funding agreement. You've got one case, you've got the funder comes in, gives money to the litigant, and in return shares in the results of that case. Even here, there can be variables, as we mentioned, in some jurisdictions where it's allowed. It's very common for the law firm to join in the funding. So you end up with a tripartite agreement. So they put some of their fees at risk and in return also share in the proceeds of the case. Then you've got, as Rajat mentioned, and it's becoming increasingly common, portfolio arrangements, which is nothing but where the funder invests in a set of claims, either owned by one claimant or one company, or sometimes owned by or being litigated by one law firm. Aggregating claims theoretically makes funding cheaper because, again, theoretically investing in a portfolio is thought to be less risky than investing in a single case with a binary outcome. But I think that really depends on the quality of each portfolio and the quality of each case in that portfolio.
We had a subprime meltdown very recently.
But there are some other very interesting structures out there which I think can be really helpful. I mean, nowadays you see litigation funding mixed up with working capital financing. So say you've got a claim, say you've also got working capital needs as a company. Now, depending on the size of the claim and what the expected return from that claim is, a part of the funding that you get against that claim can also be used for your working capital needs. And that's really, really helpful, I think, both in a formal insolvency setting, but also for companies who are a bit cash strapped. So they've got a great claim, but they also need a bit of money to just help them, keep going while the claim is going on. And then speaking of insolvency, you can also just sell your claim outright. You can, you sell your claim outright to a funder and get cash up front, and then let the funder bring the case, run the case, and it's out of your hands entirely. In most common law jurisdictions,
are we seeing CLDs, collateralized legal disputes?
I'm sure it will come. I mean, in common law jurisdictions, you do see it's not actually it's theoretically, I don't see why not, to be honest. Have I seen that many of them? No, but of course it's possible.
What's stopping it?
Sorry?
What's stopping from like classic aggressive investment bank to come in and say, you know what, we're going to do a roll-up of litigation finance. We're going to buy a whole bunch of court cases across the country. We're going to pull them into these collateralized legal dispute structures, and we're going to sell them to qualified investors.
So I mean, perhaps one limitation is, at least in common law jurisdictions, this is actually very restricted. Outside of the insolvency context, it's just not allowed. But it is allowed. It is allowed in various other civil law jurisdictions. It really just depends. It depends on each jurisdiction. That's why you'll often see in certain European jurisdictions, when there are class actions and so on happening, all the claims will be packaged up, put in a separate SPV, and then litigated out of there.
That's strange. I usually thought common law sort of was ahead of civil on these.
I suppose they're just different, I think.
It's different, okay.
I mean, there's no better or worse structure, really. At the end of the day, I think it depends on what a company's needs are, the dispute at hand, and the jurisdictions involved. Whatever you do, you sort of want to make sure your structure works for you, and also that it's enforceable. I think one thing to maybe add is, we've been talking about claimant and litigant and using that interchangeably, but it's just worth bearing in mind that you can also get funding on the defense side if you're a defendant. That can be structured, again, in a number of ways. You can tie it.
Can you give an example? If you're a defendant, there are certain jurisdictions which force the other side to pay costs, right? But apart from that, how would a financier recover their money? I mean, would it come from the person's balance sheet?
For one thing that you often see is you can tie funding to a non-monetary win. So a win, for example, that allows a defendant to hold on to some right or asset. So let's for example, say there's a win in a case for a defendant means that they continue to have a right under a distribution agreement to continue to distribute a product. So you fund them, and the claimant has essentially saying this should be terminated. You fund the defendant and the defense is successful, and as a result, they're able to continue to distribute that product and they get income from it. So as a funder, you can tie your returns to that income stream. So it depends on each case. It's very common, I think, in IP defense cases, something like this.
It makes a lot of sense, right? Trademarks, patents, etc. would have income streams that you could then push it in. And I guess it makes I think make a very valid argument there. I think it makes a lot of sense, particularly for companies to really manage their risks, right? If they have an intellectual property asset which they want to protect, but they could win or lose. There's the risk. If they win, fantastic. They get revenue stream, and sure, let's share that revenue stream with somebody else in a third party, and that works really well. Versus, going down the rabbit hole, spending all this money only to lose the case, and then you are not only out of that revenue stream in front, but you're also out a huge amount of money that you spent trying to get there. I think that's a brilliant example. One thing, to bring back to the Indian context as well. You specialize in cases between India, US, cross-jurisdictional there. Where are the type of cases? I mean, we've talked about intellectual property cases. We've obviously hinted at contract disputes, all of this stuff. Distribution agreements have been thrown out there. But what are the majority of cases do you see that really happen in this cross-border India-US in particular?
So I think I would categorize again, I like big pictures. I think if you just look at litigation and arbitration as two buckets, and I think over the last few years and recently, there's a lot of disputes. I would say a lot of issues coming. I think dispute is a strong word. Means you're ready to go into the court, and I think Indian corporations are a little bit.
Can I just pause there? Is there any way you can increase the volume on your mic? Maybe from your audio settings in Zoom. Turn off the automatic adjust microphone volume. Sorry, everybody. It's just I think I'm having to increase my speaker volume by loads every time Rajat speaks. I presume our audiences as well. Just give us a second to sort that out.
It's not on. Maybe I'm just a soft speaker, which I am. So.
All right. We will go there. Please go ahead, Rajat.
Just tell me if it's still hard for you. I was just saying that I think the type of disputes you're seeing typically from coming out of India or has some Indian focal is basically joint venture disputes. They're especially after COVID or in COVID times, there's a lot of joint venture disputes where one of the parties has stopped complying with its funding obligations or financial obligations. So you do see a lot of financial disputes in the joint venture context that are coming out. And I think that's just from the arbitration, commercial arbitration context. But if you also look at the litigation context, you see the same type of disputes where there's a litigation in New York and there are questions asked, what can we do to get out of it? Because I think there's just a framework or this reluctance from Indian parties to obviously litigate in the US courts, just from the concern that the US courts would not be favorable to a foreign party. But from the international investment treaty perspective, we do see a lot of issues where, as I was saying, that a lot of Indian companies have investments in Latin America and in Africa. And there are a lot of inquiries that come out where they are genuinely concerned about disputes. And I think, I would mention that it's also about China. I think there is a lot that's happening with China right now, and there are a lot of interest in how to litigate those issues, because we're talking about funding arrangements today, we're talking about all sorts of things, but I think that the fundamental issue here is also, it's not just about funding and litigation, it's also looking at enforcement. So, and the reason I mentioned that is that when clients come to you and say, we want to do this litigation or have this arbitration, but the counterparty is in China or the counterparty is in Africa, but we don't have cash flow, can we have a third-party funding? Yes, you can have third-party funding, but how do you go about enforce those judgments? How do you enforce those arbitration awards against some entity in Africa or an entity in China? I mean, if you're enforcing an arbitration award in China, it's awfully hard. So I think it's just, there's so many variables, but I think coming back to your precise question, Adi, it's just, I think it comes down to mostly, I think I would say it's the commercial arbitration disputes, especially joint venture disputes. And then I think investment treaty disputes, there are inquiries, but then more and more we do this, I realize that the Indian companies are not very, I would say, investment treaty savvy. So when you really have to bring a claim, you realize that, yes, you did invest in, let's say, let's say Bangladesh. You invested in Bangladesh, but, the entity that invested in Bangladesh was a Mauritius entity, was not an Indian entity. So you cannot really take the benefit of the investment treaty. So all of those options fall apart. So I think there is a lot of movement, and I think there will be a lot more movement after this so-called suspension of the Insolvency Act is lifted next year. And I think, so I think we will see what happens next year, but there's already a lot of movement right now in the joint venture context.
Brilliant. I mean, I'll just add my 1 or 2 cents there. I think, most of the cases I've seen are exactly as you said. There's usually commercial contract, joint venture disputes, things that sort of went wrong. And, and I think one of the things that Indian companies do wrong in particular, and we've certainly been guilty of it at our group, is that we are more comfortable litigating it first in India, because we're worried about costs. In the US, we are uncertain about the jurisdiction, God knows the costs, we're not comfortable with the framework, only to realize 5-10 years down the line that quite frankly it was the wrong jurisdiction. And that a lot of these cases are protected by investment treaties. They are protected by cross-jurisdictional issues, and you could have brought the case anywhere else, but it would have gone smoother, faster, better had you initiated all the work in the US, in the home jurisdiction, where that case could be litigated, and took advantage of the speed of the courts. And then I think litigation finance would play a very big role in that, because again, a lot of small, medium business companies, and some of their claims are large. I've personally seen a few companies which have 30, 40, $50 million worth of claims that are very reasonable, and those could be enforced. But because they are comfortable in the Indian system, they go around in circles. And had they first sort of litigated that claim in the US to start with, they might have found a better hearing there. And certainly their mental worries around costs could have been defrayed had they known about the opportunities to find someone who was helping them to do finance. As Sindhu said, it's not just about whether you can afford it or not, is how it looks on your balance sheet. Do you have the cash flows? Are you really able to be made whole by this award now, or does the risk in terms of paying again and again and again and again, month after month, seeing those hourly invoices from lawyers is never a fun thing. I don't think anybody's just seeing that, hey, we had a 5-minute conversation and I'm out, $200. That's a huge shock for Indian businesses who want to sort of mentally prepared that they have to pay, by the hour in 15-minute increments. and just for a small talk as well. And those things, I think, put a mental block. If they knew that they could finance it through a proper governed process, I think a lot of companies would be a lot more comfortable in going for the appropriate jurisdiction would have been in the US in the first place, rather than mucking around in India, hoping that somehow they could get some sort of judgment and then take it to the US to try to do a show of cards and enforce. Rajat, you have something to say on that?
I think that's an interesting point you mentioned, and I think it's really relevant because as I have focused on India over the last few years, and I think maybe it's just the Indian approach to doing things, or growing up in India, I've seen that when we used to go shop, and my mom would always want to bargain, and sometimes we would compromise quality over quantity. And I have noticed that when Indian corporates look for a lawyer, I think oftentimes quality is compromised, or at least in the legal world, when it comes to disputes, there's not that much sophistication to appreciate why we need a good lawyer. And I think the idea is that if we can find a lawyer, that's good enough for me, because all I want to do is fight this. But I think you will see a huge contrast compared to Indian companies or individuals and the US, at least. I can only speak for US, that when you see Indian corporates coming in, there's so much more emphasis on bargaining and fighting about fees, which is fine, you should totally do that, but there's less emphasis on the experience, the quality, why I need a quality lawyer. And I think a lot of times I've seen that you end up going to a lawyer that's not a quality lawyer, and it really backfires there. And I just think that it is a struggle that's always there. I don't know if the attitude has changed over the years. And then the second big struggle with third-party funding coming from Indian context is that you enter into a third-party funding contract with an Indian company, they agree to share the revenue stream if they win, and then they challenge the third-party funding agreement in the courts. So the funders in general are like, why do I go and fund someone in India when I'm concerned that they're going to challenge this very contract that I'm going to spend 4 years paying them? So they're very overall, there's a concern, and there's a concern about funding disputes that are based in India, because Indian courts are very
they're very unpredictable for sure. Sindhu, I mean, global context as India, where are you seeing third-party funding really happening? I mean, are you even seeing anything happening in the India thing beyond? Where are the countries that are really focusing on this?
Sure. I mean, there's no doubt, as Rajat said as well, that COVID and all that's happening right now is giving rise to a whole host of disputes globally. There are this sort of contractual disputes we all expected, I think, from day one, because of supply chain disruptions and just people being unable to perform obligations under the contract. But interestingly, we've all seen the impact of lockdown and other actions taken in different countries and the impact that's having on businesses. And it's a matter of time, I think, just before claims come out of that against own governments or, via treaty arbitrations, because equally governments currently everywhere are doing a lot to prop up local businesses. Query whether that gives rise to a BIT claim of some sort for foreign investors in those countries. And I mean, Indian companies obviously have a lot of outbound investment. So that is a route they should certainly be exploring if they aren't doing so already. We see sort of, mandates like that. We continue to see just a whole host of disputes, commercial, class actions, because again, share prices have crashed. We continue to see, in Europe at least, a lot of claims coming in the competition space, increasingly a lot of data privacy breach sort of claims, which can be grouped together. In terms of India and what we've been seeing, and when I say disputes coming out of India, I don't mean Indian seated arbitration or Indian litigation only, but foreign arbitrations and litigations that Indian companies or their foreign subsidiaries may have. In fact, those tend to be most of the referrals. Quite similar to what Rajat was saying, actually. In terms of sectors, I think we've seen claims from the mining and infrastructure sector quite a bit. Types of disputes have varied considerably, from your simple contractual claims to corruption claims, antitrust claims in the US. We have seen claims with an insolvency angle. I'll say, notwithstanding the moratorium, not a huge amount, but some. So some sort of classic insolvency type claims where companies are already insolvent and the insolvency professional is trying to recover proceeds from promoters and so on. But equally, I think more commonly, you've got what I essentially call pre-insolvency situations, which cash-strapped companies already working with their creditors to avoid formal insolvency. They've got good claims, but they don't want to dilute whatever little cash they have even further in bringing the case, because presumably the creditors want to keep that as some sort of guaranteed recovery for them. So instead, they're having to go out and get litigation funding to pursue their litigation claims. That I think we're probably going to see more and more of in India.
I think that's a very classic case for funding, right? You have a a very elegant structure where it fits in not just in terms of a risk, but it actually makes the system more efficient. And I think that's something that I think has a lot going for this, compared to even 10 years ago.
And in some ways, it goes to, I think, something that you said right at the beginning about the sort of moral hazard, if any, of litigation funding. I think this is actually a classic situation where of a meritorious claim that could not have been brought without litigation funding. And fundamentally, I think we can probably all agree that from a rule of law sort of perspective, good claims should be brought. Money should not be a constraint. Otherwise, you're never going to have contract adherence. You're never going to have rule of law. So to the extent that litigation funding enables companies to pursue good claims, and because of its non-recourse nature, why would a funder put its money behind a bad claim? I think I actually don't think, I think it's the other way around. I think it's actually good for rule of law. It's not a moral hazard.
I'm fully on that. I think the more and more as we deep diving, things are becoming very clear that it serves beyond the extreme ends, there's a huge middle ground where this really covers a lot of just basic business efficiencies. Forget about trying to look at the morality around it. We have about 20 minutes or so on the clock, and what I'd love to get in is a little bit more of the nitty-gritty. How does this actually work? I'm going to, because we've talked about it in context, we've talked about why it's important, we've seen the industry, but just a close-up of how does it work. When you are looking, when clients ask you, for example, hey, help me, this is a great case, we love it, you're like, okay, this is a good case, but guess what, I think we need external funding. What do you look at in trying to find someone who can fund? How do you run that process with clients?
Yeah, that's a great question, and I think that's it's the most critical aspect of getting funding for a client. So oftentimes when clients come to us and say, we have this case, we just don't take client by the word. So what essentially happens is we spend around 300 hours, which is a significant time, to review the documents. What we do basically is we have a call, we understand the dispute, we send a document request to the client, and then we get all the documents. Sometimes we get 200, 300, or 400 documents from the client. You review those documents, and then you prepare a really detailed memo which is essentially for funders. And I'm not just saying one funder, it's basically written so that you can take it to any funder and say, please look into this. So the memo essentially outlines the facts, the merits.
So pause there. Who pays for this? I mean, 300 hours, that's anything between lower end 75K, higher end 300K, right?
No one pays for it. So I think that's why not every firm, every lawyer is into the world of third-party funding, because there's no shortcut to this. That's my critical point. Third-party funding is all about everyone should have a skin in the game. Let's just say it, for lack of a better word. And if you are a law firm that's looking to help your client, the law firm would spend that much time in looking at all those documents. No one is getting paid at that point. It is from my experience. And because we also show a funder that I believe in this case, I have a skin in the game because I'm taking a risk. I've spent 300 hours of my time into doing this. And the funder appreciates that. And then you basically write from merits to quantum, and the most critical part about enforcement. You say, we believe in this case, we've reviewed the contemporaneous documents. So if you're an Indian corporation or any company, it's important to have your documents in your system from the time of the dispute or the time of your investment. So you can say, when we invested, we expected X million dollars. So basically we look at everything, put a memo, which is around like 30, 40 pages long. I would say on average 20 to 40 pages long, very detailed, with all the documents as exhibit. And then we basically decide who should we approach, as you asked. Basically depends on the dispute. So some funders do not fund investment treaty disputes. Some only fund commercial disputes, and vice versa. Some funders have a cap saying they will only fund up to 5 million. Some, like I understand Innsworth, do not have any cap, which is great for a law firm and a client perspective. And you say, look, we want funding for this dispute.
So sorry, just a step back. What's the size of the pool you approach? Are we looking at 20 people, 5 people, 3 people? Do you approach them all at once? Do you go?
No, we don't approach all of them at once. It's basically sometimes a firm has a good relationship. Or someone, like if I know Sindhu, I will first call her and say, because there's also a matter of trust. You need to trust someone.
You have worked with them before, right? So if you're saying this is a great case, obviously that has to come, right?
There's a presumption that it comes from a good firm. There's a good lawyer involved. They've done good work. I can spend my time opening this memo and looking at this case. I will read this 30-page memo that Rajat drafted, and then basically it's not just a memo. You send them all the documents, and then you have a budget. As a law firm, you propose a budget that, look, we think this case is about $400 million or $100 million or $50 million. And if we litigate this is a budget. On average, it can take $4 million or $3 million. And it's not all law fees, legal fees. Most of these cases are expensive because of the fees for experts and the quantum experts, because we hire them.
Do you take a haircut?
It depends again. So I think typically if the funder comes and says, basically there's a haircut proportionate to the risk you take. If the funder says, we appreciate you spend 300 hours in putting this memo together, we still want you to take more risk. So we can know that you believe in the success of the case. Then we will say, and it's normal for, not just for myself, most of the firms would do is they will take a success fee, or there's a waterfall arrangement that's typical for third-party funding, which is not significant depending on the risk you're putting in. If the funder insists that you take 50% cut, then of course the success fee goes up. But the client interest is the most important thing. You want to make sure that the client also walks away with significant amount. So essentially, as a first step, when a client comes to us, we do this work, we put together a memo, talk to a quantum expert, we talk to someone who says, okay, if you're going after a company in Africa, you can find their assets in these jurisdictions, in India or in Pakistan or in Bangladesh, wherever. And then we go to the funder, and then we start a conversation. And basically in that process, the funder will look at it. They will say, we like this case. They will issue a term sheet, which will outline the basic terms. And essentially the reason why you also don't want to go to all the funders at the same time is if you go to the first funder and they like it, the one you really have a good relationship with, most of the times you enter into exclusivity phase. So you enter into a 40 days exclusive period, which will say, I will only work with you. We will do due diligence together. The funder will hire a law firm, and the law firm, which I was mentioning before, that law firm will deconstruct the memo you put together, and the funder pays the law firm. So, you know, a law firm will charge a fixed fee. And then if that law firm comes to the funder and says, this is great, and it's very exhausting process. You get a multiple calls, there are a lot of, you know, memos written in that phase. So I would say after a lengthy 5 to 6 months time frame, you end up getting a funding agreement from a funder who is comfortable doing it. But that's the process from the law firm perspective, and I'm sure Sindhu will have a lot.
What's the process from your side? I mean, clearly this is the business development acquisition process seems to be very lengthy. How do you deal it from your side?
So sure. I mean, in terms of process, I think what Rajat said is quite spot on. I think, you know, you get approached by a law firm with a case. You do a quick assessment of that case. If it's prima facie sort of meets your investment criteria and the types of cases you like to fund, and you think this looks good based on your experience as a litigator as well, you'll say, fine, let's spend the time and the money to investigate this and due diligence this further. That process can be 30 days, it can be 60 days, it can be months. That's entirely dependent on the funder, and also how well prepared the case is when it comes for funding. There are a number of things a funder looks at during this process, really. And but fundamentally, if you think about it, you know, what they're trying to assess is legal merits and economic merits. Is this case going to succeed based on the law and the evidence that's available? How much is the funder being asked to fund? How long will it take to make any recoveries? Will you make any recoveries, and how much? And where does this leave everybody? Does this leave the funder with an adequate return? But does it also leave the claimant with a fair share of the proceeds? That's fundamentally what you're trying to assess. In assessing that, you're going to look at the legal and the factual arguments of both sides, the evidence. You're going to look at the legal theory that supports the damages claim, as well as the expert evidence that supports it. You're going to look at the jurisdiction involved, the budget that the lawyers prepared. Is this realistic, or are they going to overshoot this? You're going to look at the defendant. Are they going to are they going to pay up when the day comes, or are they going to fight it? Also, do they have the money to pay up? You're also going to look at the claimant. Is this a pragmatic, commercially minded company that you can work with? Also, are they motivated? Are they going to invest enough resources to successfully run the case? And as Rajat said, I think perhaps one of the most important things you're going to look at is the counsel team. Do you believe in the counsel team? Do you believe they will take the case through to a successful outcome? So there's lots of things, and it really depends on each case, really. But I think fundamentally, just remember, in some ways, they're looking at legal merits and economic merits.
Just to understand, right, from a general industry funding perspective, not specifically your firm, of course, is there a benchmark of cost to reward ratio that is sort of the average target that people look for? I invest X, I should at least get this much back.
So there are a couple of, I think, sort of ratios that are sort of broadly mentioned across the industry. I think one is the budget is to claim value. People tend to look for 1:10. That's a sort of shortcut to working out whether there's going to be enough money in the kitty for everybody. In terms of the returns that the funder expects, I think there's much more variance in that. There's no real standard. It used to be the case back in the day that funders wouldn't do it unless there was at least 3x what they put in. But I think that's really changed, with things with portfolio funding and just how, as you mentioned, how much money has come into the funding industry and how competitive it's gotten.
So,
and some cases are riskier than others.
So, on a portfolio basis, right? A lot of people I know will be very happy in today's economy with a 7 to 10% reasonable return. Is there sort of an industry average now post the collateralization of all this portfolioization?
I mean, there's a general sort of thinking out there that portfolios should be cheaper, but I think I mentioned this. It really depends on the portfolio. A terrible portfolio, there's no reason it needs to be.
A terrible portfolio is a terrible portfolio. Is a terrible portfolio. Right? It's not going to change anything. but I mean, it's like an asset class, right? So if I'm investing in hedge funds, I expect X return. I invest in VC, the top 10 companies deliver X returns. If I invest, in XYZ industry, the top 10 companies, let's forget the chat, like the top 10 companies, what are sort of the returns are they sort of aiming to do over a large portfolio? It's obviously they're not going to bank on 2-3 cases.
Sure. I mean, I think apart from sort of the 3x, which seems to be the
risk-adjusted thing, right? Yeah.
Yeah, that's the sort of gold standard, and sometimes it's a lot more than that if it's in, if it's a novel area of law, if it's a claim that's never been brought before.
So what I meant was I'm trying to find out on the other side. Like you have all these cases, win-loss, 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 win-loss. You average it out. What is the yearly return?
Of course. I mean, I think so. It depends. Each funder again is different. So for us personally, we look at each case on a case-by-case basis. We don't sort of work towards overall targets at all. Beyond the point, I won't be able to answer that question. But
I understand. So you aren't doing a portfolio approach. Okay,
no, we don't. We
20
don't sort of
portfolios. We have, we put in $100 million. In 5 years, at least year on year, we should be earning 12 to 15%.
No, we tend to look at the merits of each case, and if we like it, it doesn't matter if we've done 5 other of the same kinds of cases that year. We'll still do it, but it depends on the merits of that particular case.
Fair enough. I'm just going to try to go a little bit more into the operation. So I think I'm getting a lot of questions. I'm going to try to combine all of them into you. We talked about this very briefly, and I'd love to get more of it because I have a lot of questions about the Indian context. Is that have you seen good structures in which people are able to get around the India side of litigation funding for India, or is that still a black hole?
I think, at least from my side, I have not so far seen any problems getting around the problem of like an Indian litigant, because at least from the investment treaty side or the commercial side, I have never seen that problem, and frankly, some of the Indian clients have never asked for third-party funding because they're comfortable paying for litigation fees in New York or an arbitration. But as I was saying, I think most of the time there is a structure in place where even if the claimant is an Indian claimant, the parent company is a BVI entity or a Dutch entity or a UK-based corporation, and then you can structure a funding arrangement with that. And also, a lot of times, even if you have an issue with the Indian entity, a lot of times we have seen that funders ask for a guarantee from the parent entity. So there's a revocable letter of guarantee saying that if based on the issues we know, the facts, something goes wrong, here is our letter of guarantee. And I think that gives a huge comfort to the funders to see that there's a skin in the game, which I said before. Is just you just don't want, it's not just one-way street. Let me put it this way. I think it's you go ask the funder, there's an ask from everybody, from a law firm perspective, from your lawyers, from your company perspective, that whether you're willing to give a letter of guarantee. So I think that's helpful. And we will talk today very quickly on the security for cost, whether the parent company will guarantee payment of costs. I think it really helps the funders move the needle. And so I think there's an ask. I don't think the Indian problem is a problem in itself. And frankly, as I said, it hasn't been tested yet. So there has not been a case in U.S. Indian Supreme Court or Indian, Delhi High
Which
Court.
has someone really gone ahead and got that type
That
of
is
structure
it
done.
can be, because someone can say it's against public policy and you do it. But I think, again, it depends whether you're funding a claim or you're selling a claim. And as you may saw, I saw it last night when I was looking up some issues. I think Blackstone bought, millions of dollars of claims from Hindustan, Coca-Cola, the whole portfolio of litigation. So it was quite interesting to see that.
So I mean, experimentation is going on there, right? So and at a fairly large level. We aren't talking about, again, some quiet loan shark somewhere, behind the scenes. These are very public deals. I mean, we have maybe about 10, 15 minutes left on the clock again. Going down into some integrity, the actual funding agreement, right? What are some of the clauses, starting with Sindhu, then back to Rajat? What are the important clauses that people, I presume these are massive agreements, right? But what are the major important clauses that, both sides should pay attention to, that these really are the ones that you need to negotiate and, look at first?
Sure. I mean, as you said, like, it's just like any other financing agreement. They tend to be very, very complex agreements. Very key, I suppose, if I had to pick 2 or 3 important clauses, one would be those that spell out the extent of the funder's funding commitment. Who bears the cost of any overages or digressions from the approved budget you start out with? That's something that's quite important. Settlement, the claimant's obligations to consult with the funder in considering settlement. What happens if they disagree? That's something you need to provide for. And then I think termination and discontinuance. So one, can the funder terminate or stop funding? In what circumstances? Can a claimant stop taking funding and just decide to self-fund somewhere along the way? In what circumstances? Can a claimant actually just discontinue the proceedings, just drop hands and say, I don't want to do this anymore with a funded case? Again, the circumstances in which these events occur, what the consequences are, I think should be thought about and spelled out.
From your side, stuff that you should look out for, your client should look out.
I think that's exactly, I was going to say, the issues. And I think obviously because we do more client-facing dealing too, I think for us, we have to make sure the client is comfortable with the waterfall structure as well. So I think that's where also there's a lot of back and forth, but I don't think it has ever been like the bottom line issue, because I think that, as you said, I think it's an immensely complex contract. You need to figure out not just the economic consideration, but also legal. And there's also privilege issues, and you want to make sure there's always a clause that ensures that you have full independence in the way you actually litigate your cases. But I think I'm completely on board with what Sindhu just said. I think those are the issues that are often negotiated.
So, there's one big question which you all have to answer before we sort of, close out. We have a couple of people in the audience actually who even asked this, but, talking about how do you combine various aspects, for example, AT and security for costs, right? And Rajat, can you explain just on, adverse cost rules in international disputes, and then of course with AT insurance and security from cost applications, how do they come up, and how does that interact with the entire litigation funding, and what type of disputes do these actually apply to? A lot of people, including me, always confuse, is this finance or is this insurance, right?
Yeah, I think the key is to understand that when you, like, as we started this discussion, we said third-party funding is not a taboo. And of course, the flip side is that if you are someone who has taken third-party funding and you go to the tribunal and say, we have third-party funding, just to show like, how good your claim is. The flip side is that the other side can come and say, look, these guys have no money. And if they lose, I'm going to spend X million dollars, say $6, $7, $8 million in defending this arbitration or litigation. So I need assurance that if I win and I get an order for costs, I would be able to recover this from the claimant, because the tribunal can give me $7 million in arbitration costs, but who will I chase if I win in defending this case? So that's called like the security for costs decision. And most of the times you see an application by a defendant. And in my experience, it's a really high standard in arbitrations that you have tribunals giving security for costs decision, because the tribunals not just look at the fact that you have third-party funding, you also look at the issue of access to justice. If I recall, there was a recent case where a treaty case was brought against Turkmenistan, and the tribunal basically struggled with the issue of security for costs, because they said, if we give security for costs, you're basically going to end this arbitration, because there is no way a claimant can give this security for cost. Because security for costs involves you go to a bank and say, can you please give me an assurance, or I think it's a credit line, that it can be drawn upon by a respondent if they were to win. So oftentimes, so like in this case, Turkmenistan case, the tribunal declined it because they said it's access to justice, which is a principle under international law. If we award this, the claimant will be prevented from bringing a claim against Turkmenistan. And it's the only cases I have seen this. I think there are only 2 cases so far in investment treaty side. And in those cases, the security for costs, there was one case against Venezuela too, was awarded because at least in one case, there was a very notorious behavior or a history of a claimant, because claimant was known to bring these cases all the time and has brought in parallel proceedings against defendant, has lost those proceedings, or has been asked to pay the award and has not paid the award. And the tribunal said, well, given the pattern of abuse of process, we are going to issue a security for costs award. But most of the time, the tribunals are very reluctant to order security for cost award, because it really overlaps with the access to justice principle. And I'm, Sindhu can talk also more about this, but I think oftentimes you can get around it either by a funder agreeing to give security for cost, or 2, you can have a letter of guarantee from a parent of a claimant. So if you have an Indian entity, a claimant, but a parent is based in UK, you can have a letter of guarantee that will give assurance that they will pay any adverse cost award. And third is you get an insurance, which we call ATE insurance, which are very difficult to get sometimes, especially, I don't know how it is for a claimant. It all depends on the jurisdiction of the claimant. So if you don't have a claimant who's based in Africa, I think it's awfully hard to get ATE insurance out of someone in Africa, probably not as much as Mauritius. So I think it again depends on jurisdiction to jurisdiction. So, and there are brokers, it's funny that, there's someone doing something in today's world, but there are brokers who actually specialize in offering ATE insurance, and you give them a call and they give you like the rates and everything. So, but turning to Sindhu on that.
No, it sounds like a full industry. So I mean, we are now if you have dedicated ATE brokers, we are approaching a very sophisticated, well-done thing. Clearly, there's enough business that a bunch of people can make a living off just broking those things, right? Your thoughts on this? How does this all sort of tie together?
I mean, absolutely. For ATE is a big market, mostly centered in London. ATE insurance is oftentimes actually even when you get a litigation funder involved, they will insist that you have ATE insurance in place as a precondition before they fund the litigation, because the adverse cost exposure in jurisdictions like the UK can be so high.
I am going to pause there, right? So what you're saying is that before even you would love to have the AT insurance already in, right?
Many funders. So
many funders. So who does that? The client gets it, the law firm gets it. Is that part of the process?
Exactly. So I think when it is a precondition, then it's the claimant, but usually the law firm for the claimant that's going out into the market and trying to place ATE insurance, working with these brokers, or just if they're a law firm that's often on the claimant side and is used to this, they will have their relationships with the insurers. So that's who would do it. On the other end, you also have sometimes funders will take on the adverse cost exposure and underwrite that risk as part of the funding agreement. That tends to be our preferred approach because we don't like to make the claimant go out into the market and get insurance. It can be a difficult and expensive process. And particularly for claimants, as Rajat mentioned, who are not used to dealing with the market.
Makes a lot of sense. Rajat, from your side, how many of your clients take AT when they're not seeking funding? Is it just a normal thing, or it's usually because the funder has asked for it?
I have never seen a client, like we don't do this ADE insurance and litigation. At least I have not seen it in my experience, and I don't want to generalize, but in my only experience is that, as Sindhu said, a lot of funders do make it a requirement as part of their funding agreement that they want ADE insurance, but not everyone does. And if you don't have ADE insurance, I think, and if you think there's a risk that there will be a security for cost application from the other side, it always helps to have AD insurance because at least in one case, which was a dispute against Italy, there was an application for security for costs for I think 600,000 euros, and there was an ADE insurance, and then the tribunal said, declined to issue security for cost because of the AD insurance. So I think it can help you down the line in the litigation where there's a concern about security for cost application. But if you, for example, if you are a claimant who, if you think that there is no such concern when you're in arbitration litigation, I have not seen that happen.
So I'm going to just end on one last question we have from the audience. Who are the ambulance chasers in the funding world? I mean, do those exist? Sort of a funding companies who sort of proactively look. So far what we've heard is a very sophisticated market, good relationships. People do a lot of due diligence. Do we have ambulance chasers as well in the industry? I'm sure they give it a bad name, but people sort of opportunistically hunt down and step into these cases. They crawl through courts of records and they find good cases and they approach clients and they say, hey guys, we'd like to fund this.
Sindhu, why don't you go first and I'll tell you.
I'm personally not aware of any of them. I can't comment on whether or not
of this, right?
I suppose one of the inherent checks in this whole process is the fact that it's non-recourse funding. It just stops you from why should a funder try and bring a frivolous case? There's just, if you're going to lose, it's a lot of money lost. I think that's a sort of inherent check on funding being used to pursue unmeritorious cases. But to the extent that funders or law firms even are sort of trying to bring good cases that otherwise could not have been brought, I'm not sure there's any moral hazard with that at all. Good claims should be litigated, and that generally helps the justice system on the whole.
Rajat, ambulance chasers.
Yeah, I would just quickly add that I think I'm not even sure. There are no ambulance chasers. I think, in fact, when I've seen that in my practice, and in fact what I do, I think it's part of my solution to the client. And when we talk to our clients, when we approach a client, or a client approaches us, I think this is part of a solution to the client that, look, this is a fee. We understand you may be, under distress in this environment, especially in the pandemic. we can help you get around that if you want to third-party funding, and then we introduce them to the third-party funding idea. So I don't think it's ever someone like, we don't like scour the dockets and for arbitrations and say we will fund this. I think it's always the other way around. It's the problem-solving strategy for the client when the client is already talking to us in a conference room, and then we say these are the different fee arrangements. If you can't work with this, here's this third option. We are willing to invest our time to do this. As I said before, it takes a lot of time. So I think, but we offer that still as a new, modern, contemporary fee arrangement for clients. But there's no such thing as ambulance chasers. I think it's only good for the movies now.
Well, thank you so much, Rajat. Thank you so much, Sindhu, and thank you. I think we managed to cross 200, 300 people who are live on this. I know there's a lot of questions, particularly on LinkedIn and YouTube, which we just couldn't get through to. I tried to pack them all in and cover. I think we've got into a lot more of the operationals. There's a huge number of questions on the India side, and I purposely didn't get into them because honestly, this was more for cross-border around the world, and of course, bringing in the India part as well. I also want to tell our audience that, there is a vast world out there. There are companies which are using technology solutions to bring in a different perspective. I know there's a company called The Legalist out there. Sindhu was mentioning a couple of other data-driven companies who are able to bring in a lot of insight and predictability into this. And right now, I think the industry is still very much as Sindhu and Rajat had shared. It's not you can't go online, type in your case dossier number and suddenly get a yes or a no as you would, for example, for a personal loan or something else. It's a very long evolved process. It takes months and very close coordination between the multiple stakeholders. But I think there is the opportunity here and the opportunity that's just as in every other industry, maybe in 5 to 10 years from now, once those data sets are developed, for perhaps very cookie cutter straight up cases where there is a lot of data that has been generated, that we are going to see a lot more tech solutions coming in to streamline the assessment of risk. And I think this industry is only going to grow. My deepest thanks to Sindhu and Rajat. I know you guys are super busy and you bill insane amounts per hour. Thank you for the free time and advice for our CII members and all those who have joined us from around the world. This has been very enlightening for me as well. And I'm just grateful that you guys could, sit through and, very patiently walk us through the basics bit by bit. So thank you so much for being with us.
Thank you.
Not at all. Thank you. Thank you for having me. And equally, if there are sort of follow-up questions people have, I'm sure Rajat will say the same. We're happy to be directed our way.
Yes, if anybody wants to be in touch with them, drop us a line. You have our CI information, you have our numbers. We will put you in touch.
Thank you.
Thank you.
Thank you. Have a great evening, everybody.